Okay, hi. I want to use this video to present about 20 minutes of lecture that we didn't get to on Wednesday, so you have it available for the weekend. And this might help us move things along over the coming week. As I said, I'll try to have a study guide ready for you soon, this weekend or Monday at the latest. We left off on our outline reviewing, weird, huh? Reviewing the three main issues after Roe, issues left hanging by Roe. And we said there were three of these. There was spousal notice or parental notice and consent regulations, um, regulations of medical procedures, and the question of public funding for the abortion right. And we talked about the court's approach under all of those. And this is where we left off. And I said at the end that there were indications over the course of the 1980s that Roe was in trouble, that the court would probably overrule Roe v. Wade and put the abortion issue back to electoral politics in the states. One sign of this development was that President Jimmy Carter, who was president from 1977 to 1981, he was elected in 76 and defeated by Reagan in 1980, made no appointments to the Supreme Court. There just were no vacancies. The last justice appointed was appointed by Ford, Justice Stevens. And Ronald Reagan, who was an ardent opponent of abortion, made three appointments to the court. He first appointed Justice Sandra Day O'Connor, who was, uncomfortable with Roe, although there was some ambivalence in her background about the abortion right. He appointed Justice Scalia, also an ardent opponent of Roe and the constitutional right to abortion, and Justice Anthony Kennedy. He also elevated William Rehnquist from Associate Justice to Chief Justice. Rehnquist was appointed by Richard Nixon. So that's a significant difference on the court. The main sign that Roe was in trouble, and we talked about this case during the last class, was Bowers v. Hardwick, a 1986 case involving prosecution of a man named Michael Hardwick for violating Georgia's sodomy law. And we talked in class about how the police officer came to be in this guy's bedroom, he was engaged in sex with another man, and he was arrested under this statute. The book doesn't contain the statute. Bowers appears on 1043 of your book. But basically, anal or oral sex violates the law. And it's interesting that the Georgia law doesn't distinguish between heterosexual sex and homosexual sex. It says sodomy is a crime. Georgia, when it argued before the court in this case, said it could not constitutionally apply this statute to a heterosexual married couple. It didn't say anything about whether it would or would not try to apply it to a heterosexual unmarried couple. It said that it was within its authority and that the statute was constitutional as applied to persons engaged in homosexual sodomy. In Bowers, in a 5-4 decision that has since been overruled, but it's a very interesting case to read nevertheless. In a 5-4 decision, the court upholds the Georgia law against the challenge that it violates the due process rights, the right that Michael Hardwick purportedly has in his liberty, in controlling his autonomy, his sexuality. It upholds that law against that challenge. The opinion is written by Justice White. Justice White is a dissenter in Roe v. Wade. And I said in class that the thing about Bowers that was, many things are interesting about it, but the logic of it, the structure of the argument could not get you to the conclusion that the court reached in Roe. So it was an indication that the court was moving in a direction where it would be open to cases and challenges urging it to overturn Roe. So Justice White's opinion is worth talking about for a second. He begins with precedent, and this is an interesting thing about judicial decision-making. It has to refer to decisions taken in the past that are thought to be relevant. It has to argue from that. So you'll see in your book that White starts with precedent, and he has to address the fact that we have Griswold and we have Roe. And if those protect something as exalted as autonomy, and if autonomy is fundamentally about sexuality, as one could say it is in Griswold and Roe, then why doesn't it extend to cover this private consensual conduct between two adults? Why isn't there a constitutional right to control one's sexuality with another consenting adult? And he says that Griswold and Roe are the law. They do protect unenumerated constitutional rights, but like cases before them, they have to do with something that is traditionally valued: marriage, procreation, the family, parental rights, reproduction as traditionally understood. And he's not really explicitly talking about Roe, but he could be talking about all the rest of it, right? So that's a distinction. This case is not like that. This case doesn't have anything to do with the decision of whether to bear or beget a child, or parental autonomy or parental control from the state. This is a claim for the right to homosexual sodomy, right? And he says quite explicitly, we have recognized rights which have little or no support in the constitutional language, but those rights are the ones that are fundamental to ordered liberty, and those rights are the ones deeply rooted, I'm quoting, deeply rooted in the nation's history and tradition. And that may be, except for Roe. I mean, you could say, well, the abortion right is not deeply rooted in the nation's history and tradition. If that's the limitation on unenumerated rights, that it has to be deeply rooted in our history and our tradition, then Roe doesn't make sense either on those grounds. And I think Justice White would be quite happy with that implication. I think that's where he was going. And he can get 4 other justices at the time, Berger, Powell, Rehnquist, and O'Connor, to agree with him. 4 others dissent. A third indication that Roe was going to be out the window had to do with a 1989 case. This is an abortion case. It's Webster v. Reproductive Services. It's a Missouri case, and it involves a Missouri law. And this case is not assigned. It's not in your book, but I want to tell you about it just briefly before we turn to Planned Parenthood v. Casey. This also is a 5-4 decision, right? So we have a Missouri law. It has 4 provisions. It has a preamble. The preamble says, according to us, the state of Missouri, life begins at conception. Life begins at conception. Okay. What the court ends up doing with that is saying, well, that's a declaratory statement. It's an expression of a normative view, but in the law it doesn't actually do any work. The law doesn't ban all abortion. It simply regulates abortion. So you can have your claim that life begins at conception. This is a little weird because Justice O'Connor is often someone who's been very concerned about the import of the government's symbolic statements, right? What kind of message is the government sending? And here she's willing to say, well, Missouri's entitled to say this. It doesn't mean anything in the law. The second provision of the law bans the use of public facilities or public employees for abortions, even if even if it's paid for privately, right? So if we have a private doctor performing an abortion, and that doctor has privileges at a public hospital, he can't use the public hospital to perform the abortion. And no public employees can be involved in it. So it's kind of like the government saying, you know, you can do this, but you can't use any resources we have, either directly or indirectly, to perform abortions. A third provision of the Missouri law was even more controversial than that. It banned the use of public funds for abortion counseling. So we have freedom of speech questions implicated in that. No public money for talking about abortion. And finally, and also controversially, it required a complicated and somewhat costly test for viability at 20 weeks. And so for abortions into the second trimester, probably we're not talking about too many abortions, but for those it raises the cost substantially and requires this test that doctors would mostly say would be unnecessary to determine more precisely the gestational age and whether the fetus could possibly be viable. O'Connor and Kennedy vote, O'Connor and Kennedy, now they're going to be in the joint opinion in Casey, reaffirming the core holding of Roe, right? O'Connor and Kennedy vote with Rehnquist, Scalia, and White, who will be dissenting in Casey. So that makes 5. O'Connor, Kennedy, Rehnquist, Scalia, and White all vote to uphold the law. Justice Scalia says, let's overrule Roe now. It was wrong, and we should repudiate it. The 4 other justices, following O'Connor, mainly say, well, we don't have to overrule Roe. We can uphold all of these provisions, and we do uphold all of these provisions of the Missouri law within the framework of Roe. Right? Nothing in Roe says that the government can't do this. A lot of the restraints on the use of public facilities and public funds are perfectly consistent with the public funding decisions, the Mahar decision that you read. And we've said viability is important, and we've said, that the state has an interest in potential life, and the test can be justified that way. So it's all upheld, and they're very clear. We're not saying Roe is good. We're saying we don't need to repudiate it and overrule it today. We're just not going to do it, right now. We probably will do it later. That's the intimation if you read the opinions carefully. Which brings us to Casey and what we should make of it. And I've asked you in your paper mainly to focus on, I've asked you to notice and talk about Griswold and Roe, but mainly this is a paper about Casey and how we think about law and politics. And what we should make of this joint opinion by these 3 Republicans, O'Connor and Kennedy, are appointed by Reagan. Both are at best ambivalent about Roe and abortion. Kennedy is more strongly on record as being opposed to Roe than O'Connor. And David Souter, who replaced Brennan, and Souter is appointed by Bush 1, George H.W. Bush. Right. We have at issue in Casey, and it is noticed in your book, or it's listed in your book. Casey starts on 1054, 1055 of your text. 5 provisions of a Pennsylvania law, right? All of which would have been disallowed under the court's understanding of Roe through 1983. So for 10 years after Roe, if a state did any of these things, they would be struck down as inconsistent with Roe. We have 5 provisions. The first one is an informed patient consent provision. Here the doctor, and not anyone else, has to be the doctor, and you don't have the details of the law in your book, so I want to fill this in a little bit. It has to be the doctor, that costs money, must advise a woman of 3 things. He must tell the woman about 3 things: the health risks of abortion and childbirth, the nature of the procedure, and the law puts it this way, and the probable gestational age of the unborn child. And then someone, after those 3 things are talked about, the health risks of abortion and childbirth, the nature of the abortion procedure, and the probable gestational age of the unborn child, someone after that must offer the woman the opportunity to review the state's literature on abortion, which is designed to persuade the woman basically not to have it. There's information on fetal development, there's information on other options like adoption, and the state's help with pursuing child support from the father, and things like that. They don't have to look at it, they have to sign a form saying they were offered it. The second provision is related to the first. It's a 24-hour waiting period. After that informed consent takes place, a woman has to wait 24 hours. And I think it's important to think about what that might mean. If the woman is traveling to get the abortion, it raises the cost for her. If the woman faces anti-abortion protesters outside of clinics, which is sometimes the case, then she has to face them twice. It's potentially something that could cause additional inconvenience and perhaps harm to the woman and expense by making the woman wait 24 hours. The state's justification for that would be something like, well, this is a very important decision fraught with moral significance, and you should think about it. Third, the law requires that a married woman notify her husband. except under certain specified circumstances. There are some exceptions in the way the law is written, but generally the woman, if she's married, has to come in with proof that she's notified her husband that she doesn't need his consent, just the notice to the husband. Fourth, there's a parental medical informed consent provision, which is exactly like the first one, the three things that have to be told and the offer of the state's case not to have the abortion. But the offer has to, the informed consent has to involve an adult if the person seeking the abortion is a minor. So the minor has to have the parent involved in that, and it does have a judicial bypass so that if the minor doesn't want the parent involved, then the minor can go to court and go through the informed consent and the 24-hour wait with the judge acting as a parent. Finally, and fifth, there are an elaborate set of laws and regulations about the record keeping and reporting that clinics or hospitals providing abortions have to comply with. There's a lot of information requested, many details about the patient, about pregnancies, about stages of pregnancy, about the nature of the procedures, lots of medical information about patients and about the providers. Well, is this justified by health? Is it designed to raise the expense? What's the purpose of really ramping up all these reporting requirements? Before we see what the court does with these provisions, and just briefly, it upholds all but the spousal notice, right? All of this is upheld in Casey, except the requirement that the woman notify her husband. And we don't have in the book the sections of the opinion where the court goes through each of these provisions and the arguments and counter-arguments about whether they are or are not an undue burden on the woman's exercise of the choice. The undue burden standard is new. It replaces Roe's trimester framework, right? So in this case, everybody, I remember it, we expected Roe was going to be overruled, and then this would be a battle in politics in the various states. And that's not what happened. What happened was three Republican appointees, O'Connor, Kennedy, and Souter, author a joint opinion. They all sign it, which is symbolically important, which, as they put it, reaffirms the central holding of Roe, right? And it's interesting to start with the summary that you get on page 1055. The way the joint opinion sets out what it's doing. I think maybe we'll just start with, we'll go through the whole opinion a little bit. I'm just doing this off the cuff, obviously. Very low production values here. I think it's fair to say this opinion offers itself up as a landmark, right? It understands the historical significance. Scalia, in his dissent, derisively refers to the opinion's epic tone, highly rhetorical flourishes. I think they know they're doing something historically very important, and they're speaking and writing accordingly. That this opinion is something akin to Brown v. Board or Roe itself. It's a landmark, right? And we want to pay attention to this theme of law and politics, of what the Constitution is, how one understands what it is, who gets to say what it means, right? That's what I've asked you to write about. And the first line of the opinion is interesting in this regard. It does capture your attention. Liberty finds no refuge in a jurisprudence of doubt. So the Constitution is about protecting your liberty. This decision is about liberty and how we protect liberty. And it's about constitutional jurisprudence, the basic theoretical propositions, the foundational propositions about constitutional interpretation and how that gets played out and how it relates to politics. And what's the role of the court in this? That's another area of disagreement. So it is Roe's notion of constitutional liberty that is in doubt and has been placed in doubt. And what I think the three justices are saying here is the time has come for some kind of clearer, more definitive resolution, and that's what we're offering. And we're going to canvass the premises, right? The basic principles from which the reasoning about reproduction and abortion proceed in our jurisprudence, right? So we have these three statements, and they're not true, but they're interesting, right? So the court says first, right, it must be, I'm just going to read this, right? It must be stated at the outset with clarity that Roe's essential holding, the holding we reaffirm, has three parts. First is the recognition of the right of the woman to choose to have an abortion before viability and to obtain it without undue interference from the state. Well, no. Roe said for the first 3 months, the woman's right was a right to obtain an abortion without any interference from the state that had to do with the moral significance of abortion, right? Or even much with regulating to preserve health. Nothing, basically. It was an absolutely protected zone of autonomy for 3 months. And here the right is a right to have the abortion before viability without undue interference. So that's a little different. Second, the state's power to restrict abortions after fetal viability if the law contains exceptions for life or health. That's accurate. That Roe did say that. So that's an accurate restatement of Roe. Third is the principle that the state has legitimate interests from the outset of the pregnancy in protecting the health of the woman and the life of the fetus that may become a child. Again, that's different. Roe said that the state had interests in women's health and potential life. For much of the pregnancy, those interests meant nothing in terms of policy. Here, the court's going to take this interest in potential life and potentiality and develop what it means and make it matter, allow it to matter, all the way through the pregnancy. There's a certain logic to that. Potentiality is potentiality, and once we understand what that interest actually is, that's not easy, then there's no reason to have a kind of a cutoff point at viability, which is what Roe said. Roe said the state's interest in potential life of the fetus didn't become compelling, didn't override any interest the woman had until viability. This opinion in Casey retains the viability line as the point after which the state can ban abortion as long as the woman may have an exception for her life or her health, but it allows the state's interest in potential life to matter before viability in some profound ways, all the while reaffirming the central idea that the choice will be with the woman, right? And the opinion that we have in the book is edited heavily. It's a very long opinion. The joint opinion is much, much longer than what you have, and I want to fill it in a little bit by going through it. From here, the three justices in the joint opinion canvass other ways of understanding liberty in the Constitution. And they say that this is tempting. It's tempting to say that we know what liberty means in the 14th Amendment because all we have to do is look at and only at the Bill of Rights. Justice Black always took this position. I know what the framers meant by freedom and liberty that the courts could protect, and what they meant by fundamental rights. All I have to do is read the first 8 amendments. And if I read anything else, I'm making it up, and there's no constraint. No guarantee that we're not being governed by unelected judges who are just legislating their moral preferences. The problem with that view, of course, is that it doesn't comport with a lot of what the court has endorsed and a lot of what we would endorse. The rights that have been protected that are not explicitly mentioned in the Constitution. A second temptation, and this is Scalia's method, is to say, yes, there are protections for unenumerated rights that are not in the text, but those have to be derived from what's in the text, or they have to be part of the understanding of the people who wrote the provisions we're talking about here, the 14th Amendment. And they have to comport with the traditions or the collective conscience of the community, or however you want to put it. But there's a limitation that goes to history and the specificity of understandings of other actors besides the justices, right? And they also say that's tempting. We're tempted because we want to evade the moral responsibility of what they're going to say is the basis for these decisions, reason and judgment. right? And what they seem to be saying, the three, to people like Justice Black or Justice Scalia, they seem to be saying, look, you know, value choices, morality and value choices are inevitably involved here. You know, that's part of this practice, part of the authority of the institution and what it does when it reads the Constitution. The difference is we're saying, let's be honest about it. There are value choices. We, the three justices in this opinion, want to convince you that we're not legislating our preferences. We're not just making it up. We have methods and ways of thinking that guide us, that constrain us. You know, we're uncomfortable with abortion. We don't like abortion very much, but we've concluded that we have to reaffirm the central holding of Roe, right? Even against our preferences. This is the case they want to make to you, or the story they want to sell you, perhaps. But reason in law is a constraint, right? We're not to legislate our own moral code, right? We are to read our precedents and our traditions for the meaning they provide about these questions of liberty. And the Constitution doesn't protect a laundry list of this or that right. You know, we've been protecting a principle, and that principle is autonomy. It goes under the name of privacy. This is again, I'm not saying I agree with them. I'm saying this seems to be the argument they're trying to make here, right? Right. The inescapable fact is that adjudication of substantive due process claims may call upon the court in interpreting the Constitution to exercise that same capacity which, by tradition, courts have always exercised: reasoned judgment. Its boundaries are not susceptible of expression as a simple rule. That does not mean we are free to invalidate state policy choices with which we disagree, right? Some of us as individuals find abortion offensive. I'm not sure whether they're talking about themselves or all Americans. It's not clear to me. But our obligation is to define the liberty of all, not to mandate our own moral code, right? Then they go on to say all the precedents where we do protect unenumerated, non-textual rights that seem terribly important. And then this first section, and if you look on my handout, I've broken their opinion up into five parts, the way they do. It just follows their outline. This is known as the Mysteries of the Universe passage, but they get to this almost mystical language, right? It's almost religious language, right? These matters, the matters that we've defined as part of liberty that are not enumerated, these matters involving the most intimate and personal choices a person may make in a lifetime, choices central to the personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. Listen to this. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. What does that mean? Well, I think what they're saying is there are certain decisions that are foundational to our concepts of personhood and constitutional liberty. If the government told you whether to believe in God or what God to believe in, it would be denying your dignity as a person, right? The ultimate decision whether to continue a pregnancy in its early stages is like that. To take it away is to take away personhood. That's what they're saying. They're uncomfortable with abortion. They then quickly go on to talk about all the reasons our intuitions, many of us, have are ambivalent about abortion, or our intuitions about why it might be wrong or might be dangerous for society to allow. They talk about that, right? It's unique and it's fraught with these issues, and that opens up a place for the state. Now, the argument, another interesting thing about Casey, though, is that I'm on page 1056 in your excerpt, your edited version. The argument could stop here, or it could skip quickly to the idea that the trimester framework was too rigid, didn't properly balance the concerns or the values in conflict, this is where they end up. They end up saying that the trimester framework doesn't properly understand the nature of the issue and the state's concerns. It doesn't give the state's interests their real due. But there are two sort of parts to part 3, and part 3 doesn't jump right to, okay, we're going to replace the trimester framework with the undue burden test, and that's what they end up doing. There's a long discussion here that's really cut up in your book. It's not easy to follow, but I'm going to summarize it very quickly. And that has to do with the role of the court as a legal institution in our system, and whether the people or others perceive it as a court doing law or perceive it as a political body making law. And it has two dimensions. The first dimension is this idea of following precedent and stare decisis. And you can see in what you have, the justices, they find this distasteful almost, right? We are unable to overrule Roe. We are, we cannot say, right? We kind of want to, but we can't do this. We can't do this because stare decisis, let the decision stand, follow precedent is important. And they talk about why that's important apart from whether Roe was rightly decided. Right? They're not saying that. They're saying, well, there's a good argument about constitutional liberty that supports Roe, but there's also this other idea of following precedent and the harm done when we don't follow precedent. There are reasons to follow prior important decisions apart from the rightness of those initial decisions. Right? All of the value we get out of the idea of and the pursuit of the rule of law is involved in following precedent. And so, in the full opinion, the justices developed this framework for when a court should or should overrule a prior case. And it seems to me to be kind of invented for the moment. Has the decision that we've made proved unworkable? Does it still comport with the rest of our law? Has that decision been overtaken in other bodies of doctrine and law that we've developed? Have the facts changed, or have our understandings of the facts changed? And interestingly, they compare their situation they're in with two prior moments where the court did overrule. Right? I mean, the rule of following precedent doesn't mean that much. This could be said of any rule. Maybe the meaning of a rule depends on there being occasions for violating it. That no rule has real meaning unless there's a situation or a context in which you should not follow the rule. So they talk about Aitkins v. Children's Hospital and how and why that case got overruled in West Coast Hotel. And they go through their framework and say, yeah, well, the case for overruling Aitkins during the New Deal was very strong. Our understanding of facts and the meaning of facts and the import of facts and our situation had changed fundamentally. So overruling Aitkins and the Lochner era was the right thing to do, and it was accepted and seen as the right thing to do. Same with Plessy and Brown. Right? Plessy had endorsed the idea that separate but equal was constitutionally sufficient to meet the command of equality, and Brown repudiated that. The same thing. Brown certainly is an appropriate repudiation of a landmark precedent. Not so here. Okay, so Roe has to stand. We're not in that situation. There are reasons to follow it. People have relied on it. They've organized their lives around it. Some of the particular facts have changed, but the basic understanding of the meaning of the decision and its relation to constitutional freedom, that hasn't changed. It's controversial. It's divisive. And then they go on to something a little different. And the argument here is bizarre, frankly. It goes like this. We have to protect our institutional integrity as an institution perceived to be the guardian of the rule of law. We have to be perceived to be legal, not political. We have to be perceived to be basing our decisions on principled grounds and not just the political preferences of the 5 people who happen to be in the majority. Right? And they seem to say, if we were to overrule Roe now when we're under fire to do it, nobody would believe that we were doing law. Nobody would take us seriously. Everybody would say it's just who's got the 5 votes. So we can't overrule Roe without damage to our reputation as a legal institution, as opposed to a crass political institution where it's just, you know, I like this way and you like that way, and we have the votes. And the line in your book that you know, it says, a decision to overrule Roe's essential holding under the existing circumstances would address error, if error there was, at the cost of both profound and unnecessary damage to the court's legitimacy and to the nation's, not just the court's, but the nation's commitment to the rule of law. There's other language you don't have where they even kind of intimate that the nation's ability to see itself as a constitutional democracy that embraces the rule of law depends on this reputation of the court as somehow separate and apart from politics. Therefore, that's an additional reason to reaffirm Roe. It's a very strange argument. It really reflects the arguments of political scientists over the past several generations, where the political scientists have said something a little more sophisticated about law and politics. The court is a policy-making political body. It's an agency of governance in the governmental process. It's part of a system of checks and balances. They're political actors making political decisions, and often doing that in much the way that anyone else would make moral and political decisions. But their legitimacy and power to do that depends on their careful maintenance of the perception that they're somehow separate and apart from politics, that they have to be perceived to be engaged in legal reasoning, and they have to be perceived to be a principled body, reasoning from first principles, reasoning from precedent. And they won't play a valuable role at the margins of politics. They won't constrain majorities when they get out of hand if we lose the idea of the court as separate and apart from politics somehow. And so if they believe their own press and think there is such a thing as economic due process, and they should and can impose that on everybody, then they'll lose legitimacy. This is the argument, and I think the joint opinion it would be weird to think that and write it. I mean, if you thought it, why would you publicly proclaim it? I don't get it. Logically, the argument doesn't hold up because it's you know, if Roe was constitutionally illegitimate and wrong in the first place, then this argument about institutional integrity doesn't really mean a lot, because why wouldn't Roe itself be the thing that undermined institutional integrity? So we go then to part 4 on the outline, where, and I can be much briefer here, Roe is revised and the trimester framework is thrown out. This is a little bizarre because they've just written a lot about the importance of following precedent, but they're not really following precedent, they're revising it. So the trimester framework, which was kind of a rule book developed to provide clarity and protection for autonomy, is thrown out. It's replaced with the undue burden test. The state can regulate to pursue both its interests in the woman's health and in potential life throughout the pregnancy, provided that the regulations are not an undue burden on the woman's constitutional right to make the choice to terminate a pregnancy before viability. What's an undue burden? Well, an undue burden is a substantial obstacle placed in the way of a woman's right to terminate a pregnancy. What's a substantial obstacle? They're not saying, and what they are saying very clearly is, we're not saying, and we'll work that out as adjudication proceeds. We'll work that out on a case-by-case basis. They're very clear that 4 out of the 5 Pennsylvania provisions, which would have been struck down 10 years prior, are going to be upheld. They're not undue burdens. They're burdens, but they're not undue. So we're really going to have to wait to see what the justices say. And your editor points out in several places that the trade-offs, the virtues and vices, respectively, of rules versus standards. Standards allow flexibility, discretion. In favor of the Casey way and the undue burden test, you could say that there's more leeway for democratic politics to operate. There's more room to have regulations or not. States and state politics are given more play in the process compared to Roe. On the other hand, if you're coming at this from a feminist perspective, we're going to have to ask judges what an undue burden is or isn't. What Pennsylvania's doing is, strikes a feminist, or even someone who takes autonomy more seriously, as highly paternalistic, right? I mean, what other right do you have to go home and think about it for 24 hours? And most women aren't already taking this decision very seriously. They need the state to remind them and bother them about it. So I've asked you to think about a couple of big things. One is, how do we reckon up the complex interplay or boundary tension between law and politics in these decisions? Right? I mean, you could take an entirely cynical view. One very cynical view of Casey, which came out, doesn't make any sense in retrospect. But at the time, it made a little sense to me and to others. It's June 1992 when Casey comes down. There's a presidential election that year. And Bill Clinton is kind of gaining momentum in a situation where nobody thought that George H.W. Bush could be defeated after the first Gulf War, and actually the main stars in the Democratic Party decided to sit it out. Mario Cuomo wasn't going to run. Bill Clinton wasn't widely known or well known at the time. If you're a Republican, do you want Roe overturned? Do you want the issue of the right to abortion totally and completely nationalized? Do you want people upset about overturning Roe mobilized and brought into politics just before a presidential election? Because if it's a national question, public opinion is basically pro-choice. If it goes state by state, then public opinion, it depends whether you're in the Midwest or the South as opposed to the Northeast or the West. Cynical view is this is really just cutting away at Roe, which is what they want to do, but not doing it in such a way to hurt the partisan and electoral interests of the elite in the Republican Party. And yeah, these are three Republicans being very sophisticated. Entirely cynical. That means all of the talk about constitutional traditions and liberty and the mysteries and ultimate secrets of the universe is all a bunch of BS. But you could still think along those lines of chipping away at Roe, of maintaining the court's legitimacy, of moving toward a situation where abortion becomes harder and harder to actually obtain, and view the court as a political actor pursuing a political agenda, defensible or not. But on that account, still, one really shouldn't take the proffered legal justifications and legal analyses very seriously at all. How easy is it for you and I to separate our moral positions about abortion from what then become our constitutional theoretical propositions about what the Constitution is and means and what the appropriate role of the court is? That's something to think about. I'm at 45 minutes. And I think I've covered what I want to cover. And I haven't covered the O'Brien chapter, which I would urge you to read. I want you to read the Dworkin piece and the John Hart Ely piece in the book. They're both very interesting, well-written, provocative pieces. And this should help work with the paper, and it should help move us along on Monday. If I can figure out a way to get this 45-minute clip up somewhere and available to you. And I'm an atheist, but I may go to church and pray that no one besides you ever sees this video. Thank you very much.